Okay, if I could have your attention. My name is Sean Leisinger. I'm director of the Centers of Excellence here at Washburn Law School. Myself and a team of folks here, Professor David Rubenstein, Professor Reggie Robinson, Marcia Boswell, Donna Vilander, Martin Wisniewski, and one of our students, Andrew Newcomer, have all kind of come together as a team, and I'm proud to be kind of the leader of that team to put the symposium event on here at Washburn for you. Very pleased to have you here. I want to just touch on a few logistics before I introduce the dean. Restrooms are out and to your left. For lunch, we ask that you come out the north door, make the loop for a box lunch, and then come back in the south door so we can get everybody through real quickly. You'll have about a half hour before we have our luncheon speaker actually speak, so you'll have plenty of time to have your lunch and then kind of get relaxed and enjoy Peter Vincent speaking over the lunch hour. The basic format of each of our 3 sessions this morning, this afternoon, and tomorrow morning will be about a 20-minute presentation from each of the speakers and panelists. We'll take about a 10-minute break and ask that you try to get back as quickly as you can so that we can get started on the actual panel discussion at that point. When the panel discussion starts, each of the speakers will be able to either make commentary or ask questions of the other speakers to start with, and after that we'll allow questions from the audience. If you'd like to ask a question from the audience, please come up to the microphone at the front so that we can hear you nice and loud and clear, and also so that we can keep it there and avoid any feedback issues that we might have. If you do come to the microphone, most of you have probably spoken there before, speak up as close as you can to the microphone so it picks up your voice and we don't have to turn up the volume. We are going to do our best to try and stay on time and keep with our format. However, we certainly don't want to cut off any good conversation, discussion, or discourse that's going on. So we may, alter a few minutes here and there. But we'd ask everybody kind of try and help us keep on schedule as best we can so we can all kind of enjoy it and kind of have an idea of where we're going throughout the program. A couple last points that I want to make. If you have a cell phone, we'd very much appreciate that you either A, turn it off if you're willing to do that, or otherwise please put it on silent so it hopefully doesn't interfere with our electronic equipment that we're using to record. If you need to take a call, please feel free to come and go and step out the rear doors at any time. If at any point anyone has any questions, concerns, issues, or anything you need taken care of, please just come to the front table and we're happy to deal with whatever comes up. That said, I'd like to introduce the Dean of our law school, Tom Romig, to basically welcome you to the event and tell you a little bit about what we're doing here. Dean Romig?
Well, thank you, Sean. Good morning. Welcome to Washburn University School of Law and to a beautiful fall morning in the nation's heartland. Now, some of you may know this area as flyover country, but I think you're getting a better feel for what it's really like here on the ground seeing it. We at the law school are very proud of our Center for Law and Government and extremely proud that they are hosting this symposium entitled Breaching Borders, State Encroachment into the Federal Domain. There's hardly a more debated topic today in the media or our political arena than that of immigration. The proper roles of state and federal government are central to that debate. You may have noticed the title of our symposium ends with a question mark, and that's intentional. Our desire is to, rather than to come to a conclusion, the right answer, if there is one, we would rather raise the level of discussion and debate on all the wide variety of issues that fall under this general topic and hopefully make everyone a little better informed on the issues. To give you a little background, Washburn University School of Law has a long history of training skilled attorneys for work in local, state, and federal sectors. That is why we are particularly pleased to have a Center for Law and Government, which will build on Washburn Law's tradition of preparing lawyers, outstanding lawyers, for government service at all levels. Distinguished Washburn Law graduates who have had careers in government include Senator Bob Dole, Congressman Dennis Moore and Congressman Jim Slattery, to name a few. Also, 5 out of the 7 Supreme Court justices in the state of Kansas are Washburn Law grads. By sponsoring events like this symposium and providing students with an opportunity to earn certificates in law and government, we will continue to send Washburn Law graduates into government service, prepared to make a contribution and a meaningful difference. Washburn Law relishes its role in providing a resource on current topical legal issues for our students, the practicing bar, our legal representatives, and our communities in general. To that end, we are pleased to bring together today a broad variety of national experts on immigration issues to discuss and debate a variety of issues, federal concepts in the area, federalism concepts in the area, and the specific roles of state and federal government. The experts that have come here today hold a broad variety of opinions and perspectives in regard to these issues. Each of the 3 panels, the first this morning, State Policy Potpourri, some comparative assessments, will be the first this morning. This afternoon, Immigration and Employment, and then tomorrow, Curtailing Birthright Citizenship. Each of the panelists will have the opportunity to present their thoughts individually and then sit together as panels to discuss and debate those same issues, as well as to respond to questions from the audience. We hope everyone will be able to leave here today understanding the perspectives, the arguments, and the positions on all sides of these complex issues. I know we have in the audience today elected officials, scholars, advocates, academics, students, and others interested in this topic. So I want to again welcome all of you to the symposium and wish you well in learning more about the important issues that we will discuss today. I look forward to chatting with many of you throughout the symposium, and I hope many of you will be able to attend the reception and the dinner with keynote address by Professor Peter Shook, this evening in the Capitol Plaza. Once again, welcome, and we hope you enjoy your time here at Washburn Law. Thank you.
Good morning. I want to thank Dean Romig for that welcome and add my own welcome to his. My name is Reggie Robinson. I'm a professor here at the Washburn School of Law and the director of the Center for Law and Government at the law school. We're really pleased that you're here with us this morning. There's a special group I want to make a point of welcoming in a special way. There are a group of 9 undergraduates from Emporia State University who've made the trek up to participate in our symposium, and I'm happy to see those young folks as a part of the audience this morning. We are especially proud and pleased of the speakers who have accepted our invitation to participate in this symposium and to share their thoughts and valuable perspectives over the course of the next day and a half. Thank you for the commitment you've made to be here. And before I ask members of the panel to come forward, I'd also like to, as Sean did, just spend a minute before we get underway thanking those whose work and commitment made this symposium possible. First and foremost, I want to thank Dean Romig for his enthusiastic, unflagging, and essential support and encouragement as we have tried to move the planning for this symposium to completion. I want to thank Sean Leisinger, the Executive Director of our Centers for Excellence, for his leadership and hard work. Special thanks to Marcia Boswell, Martin Wisniewski, Donna Valander for their tireless efforts on a range of critically important organizational fronts. And I want to thank Andy Newcomer, who you've heard mentioned before, who serves on the editorial board for the Washburn Law Journal, which will publish a special journal issue that will be anchored in this symposium. And of course, I want to thank all of our speakers who set aside the time to be here for this event. Last and certainly not least, I want to thank my faculty colleague, David Rubenstein, Professor David Rubenstein, who teaches immigration law among other subjects, and he has just been a tremendous thought partner as we've worked to pull this event together. Thank you very much to all of those folks. And could I ask the members of the panel to come forward? And as they're making their way up front, I just want to try to reiterate what the rules of the road will be as we begin our journey during the course of this symposium. And you heard them from Sean. I just want to reiterate them quickly. Each of our panelists will have about 20 minutes or so to make a presentation to you. We'll ask them to present in the order in which they are listed from my direction on the dais. After all three presentations have been made, we'll take about a 10-minute break. When we return, I'll ask the panelists to engage each other with questions or comments regarding the presentations that each of them has made. And after some of that exchange, then it'll be your turn. And I'll look to the floor for questions, and that's when you'll have your opportunity to be a part of this discussion. So as you listen to these presentations, please be thinking about the kinds of questions that you want to pose when we get to that discussion period. Now on to this panel. As you all know, from any observation or absorption of what is reported in the media, there has been, to say the least, a significant increase in state lawmaker activity on the immigration policy front. It's been all over the country, various states across the country. There's been exceptional media coverage about this increase in state activity. As that activity has increased in an area that has largely been viewed as a federal domain, thus the title of our symposium, a question has emerged. A series of questions has emerged regarding the propriety of this state activity, policy-making activity in the field of immigration law and policy. Is this wave of state policy-making activity an inappropriate encroachment onto federal turf, or, on the other hand, does it constitute legitimate state policy making that is wholly appropriate within the context and framework of our dynamic system of federalism? We have three distinguished panelists here this morning to offer their thoughts and perspectives on this very important and critical immigration policy topic. You have information about each of our panelists included beginning on page 4, I think, of your program, so I won't go into a lot of detail about them now, but let me say a little bit about them in the order in which they'll be making presentations. First, you'll hear from the Honorable Chris Kobach, the Secretary of State for the state of Kansas, who was sworn into that position as the 31st Secretary of State in January of 2011. He has served as a professor of law at the University of Missouri, Kansas City, and he specialized in that role in teaching in the areas of teaching and research in the areas of constitutional law, election law, legislation, and of course immigration law. And we look forward to hearing the Secretary's comments. Next, you'll hear from Nora Demleitner, who serves as Dean and Professor of Law at Hofstra University School of Law, and she has served in that capacity since January of 2008. She has taught and written extensively in the areas of criminal law, comparative law, and of course immigration law, and we look forward to hearing from the Dean later on this morning as well. And finally, you'll hear from Patrick J. Charles, who has an interesting role, and I look forward to hearing his perspectives as interesting and some would say unusual. He serves as the historian for the U.S. Air Base 352nd Special Operations Group in England. He has, however, in addition to that role, been active as a legal writer and scholar, and in fact was a legal analyst for the Immigration Reform Law Institute, where he specialized in constitutional analysis, legal scholarship, and Supreme Court of the United States advocacy. So I think we've got a panel gathered here this morning that is particularly well qualified to offer some valuable perspectives on this issue as it relates to state policymaking in the area of immigration law and policy. And we'll start with Secretary Kobach. Mr. Secretary, please share your thoughts. Welcome. Thank you for being here.
Thank you. So I can speak from here or there?
Your choice.
All right.
Thank you, Professor Robinson, and thanks everyone for showing up this morning for this event. I think it's a very important issue. I've been involved in this for some time now, and it's one that I think is very interesting to lawyers, law students, practitioners, judges, professors alike. It covers so many different issues. There are various social issues involved, economics, criminology, as well as very thick legal doctrine, including preemption law and immigration law, which is, of course, a very detailed specialty in and of itself. Now, I'll just start by answering the question that Professor Robinson posed at the beginning. Is this an encroachment into an area of federal authority that is not permissible, or is this a development that our constitutional framework accommodates, indeed not only accommodates, but in some ways welcomes? And I would say that it is the latter. It is not an encroachment. It is not activity that is preempted in any way, and I'll get to that in a minute, but indeed is something that Congress itself has contemplated and invited. And let's just step back for a minute and take a bird's eye view. Whenever you have any major national law enforcement problem, the question inevitably arises, or maybe not inevitably, but who's going to address the problem? And I don't think any serious policy analyst or any serious constitutional scholar would say there are some areas of law enforcement where the federal government is the only actor on the field, and the states and local governments may not act at all. We would not say, for example, in the many decades long now war against drug trafficking, that the DEA is the only agency that can intercept and move in any way in drug enforcement, and that cities and states' help is not welcome in that area. We would not say in the area of gang activity, which is an interstate and indeed international phenomenon. We wouldn't say that, well, only federal, only the FBI, only federal marshals, only federal law enforcement officials are equipped and are capable and are rightfully in that area. They don't want any help from the sheriffs or for the state and local police. It's only the feds' game. Well, so it is with immigration. Although the regulation of immigration is certainly a federal responsibility, and the Supreme Court in 1976 defined the phrase, this term of art, regulation of immigration, as defining who may enter the country and the conditions under which a legal entrant may remain in the country. That's from Decanis versus Bika in 1976. Defining who may enter the country and the terms under which a legal entrant may remain. So yeah, that's the federal government's bailiwick, and the states certainly have no authority to go into that specific area. But there's a whole lot beyond just defining who may enter the ports of entry of the United States. And that gets into what the states have done, and I'll talk about that at some length here. But one other point on this whole issue of needing the help of the states. There are a total of between 6,000 and 7,000 interior law enforcement agents at ICE. Let's say agents who work the interior of the United States, 6,000 to 7,000 total. The New York City Police Department has 35,000 officers approximately. One large city. The notion that 6,000 to 7,000 people are going to effectively police the entire United States, every corner of the United States, without any assistance from state and local law enforcement is, I think, simply A, impossible, and B, it would be a very difficult argument to make that it should be that way. And Congress recognized this way back in 1996 when Congress passed the IRIRA, as it's abbreviated, the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. And in that act, Congress included several provisions designed to specifically invite state and local assistance. One of them is found at Title 8, Section 1373, and it says anytime any state or local official picks up the phone or picks up a computer keypad and asks the federal government for an answer, is this person an illegal alien? The federal government must answer. Anytime a state or local official asks, the federal government must answer. And if that wasn't enough, they put the same provision in federal law again, in almost verbatim the same terms, at 8 U.S.C. 1644. The 1644 provision was part of the Welfare Reform Act of the same year. They also included a provision saying states could not offer in-state tuition to illegal aliens unless every U.S. citizen in that state gets the same benefit, regardless of where the U.S. citizen comes from. That was in the 1996 Act. They also said states must stop providing state and local public benefits to illegal aliens. That's found at 8 U.S.C. 1621, also in that Act. They said the federal government's got to stop providing public benefits. So the public benefits provisions were part of the Welfare Reform Act. The two happened within a few months of each other. And then there were several provisions in the Act that were designed to invite state and local help in specific areas. Again, Congress recognized that they've got to address this problem by having state involvement and by having federal cooperation with the states when they do get involved. Now, it took a while for the states to accept this invitation. Indeed, it took about 5 years. It wasn't until 2001, after the 9/11 attacks, that various states started looking at what they could possibly do. And another provision, which I didn't mention, from that 96 Act was the 287G authority, named after Section 287G of the Immigration and Nationality Act. That's found at 8 U.S.C. 1357. And Florida was the first state to say, hey, there's a provision here that Congress created that says we can deputize our own state troopers and give them another hat to wear. They can have the full powers of an ICE agent if they get this special training, and then they can sort of wear two hats. They can work part of the time as sort of deputized ICE agents. Florida was the first state to get that authority, and they did so in specific reference to the fact that many of the 9/11 hijackers entered the United States through Florida airports, and they were very concerned about it. And then Alabama was the second state, and now we have over 60 jurisdictions around the country, states, counties, and cities that have 287G authority. Then the cities and states started doing other things. The first state to do other things was Arizona in 2005, which passed its state-level anti-human smuggling law, which is the same law that Sheriff Joe Arpaio famously enforces vigorously in Maricopa County. Then the first city out of the gate was the city of Hazleton, Pennsylvania. In 2006, Hazleton passed a law saying that landlords cannot knowingly harbor illegal aliens in apartment buildings, knowingly, and that employers cannot knowingly hire unauthorized aliens at businesses in the town. Since then, we've seen a whole platoon of states and a platoon of cities join those two forerunners. On the state side, Arizona has been joined by Alabama, which indeed just this past summer enacted a law signed by Governor Bentley on June 19th, which is even stronger than Alabama's much vaunted SB 1070. Georgia has passed a similarly broad law dealing with areas of illegal immigration that the state has authority to act in. Indiana, Missouri in 2008 passed a pretty sweeping omnibus anti-illegal immigration bill. Oklahoma did so in 2007. And I think I already mentioned Georgia. Those are the big ones in the states. And the cities, you have Valley Park, Missouri, which passed an ordinance prohibiting the employment of unauthorized aliens. I've worked with many of these jurisdictions. In the case of Valley Park, I defended that up to the 8th Circuit, and the city prevailed both at the district level and at the 8th Circuit level. Hazleton, of course, as you may not know, is in the 3rd Circuit. We went all the way up to the 3rd Circuit, and then the 3rd Circuit went against us, the city, went to the Supreme Court. Supreme Court GVR'd the case. For those of you not familiar with it, GVR is a grant, vacate, remand. But the Supreme Court grants cert, vacates the case immediately, and then remands it back to the Circuit Court of Appeals. So now it's back in front of the 3rd Circuit. The U.S. Supreme Court GVR'd the case in light of Whiting, Chamber of Commerce versus Whiting, the United States Supreme Court's decision on May 26, 2011, which I'll talk about in a minute. Other cities, Farmers Branch, Texas, currently pending before the 5th Circuit. Fremont, Nebraska, currently pending before the U.S. District Court for the District of Nebraska. Another landmark that was hit at about that time was in 2007. For the first time, every state legislature in America had a bill introduced trying to discourage illegal immigration. And that had never happened before, and it's been pretty much constant since 2007. You see state legislators trying to do something to stop illegal immigration. And so we see state after state doing this. Now, what I want to do is quickly and briefly look at why the states are acting, and then go straight to the legal issues, which I think many of the people in this audience will find interesting. The number one driver of state and local action is the fiscal cost of illegal immigration. Milton Friedman, the Nobel laureate economist, said the following famously. He said, "It's just obvious. You can't have open immigration and a welfare state." It's just obvious. You can't have open immigration and a welfare state. It is obvious. If illegal aliens have access to any forms of public benefits, then they will, of course, drain those benefits. And, of course, if we want to have a generous welfare state, which I presume many people in this room think is an okay thing, then we want to be able to control access to those benefits to ensure that the welfare state survives. Now, the Heritage Foundation did a study, and this is I think the most thorough study done so far on the average cost per household, illegal alien-headed household. And the result was this. It was $19,688 per year net, a household headed by an illegal alien. Those are based on Census Bureau current population survey figures. That's net. That's after you take into account any sales taxes, any alcohol taxes, any gasoline taxes, every single tax that an illegal alien household might pay. We still end up $19,688 in the hole in terms of the fiscal cost of that. An April 2011 study by the Center for Immigration Studies found that 71% of illegal alien households take advantage of some form of welfare, chiefly food assistance and Medicaid, compared to 52% of lawfully present alien households, and compared to 39% of households headed by U.S. citizens. Again, the explanation for this is pretty obvious, too. It's simple demographics. The overwhelming majority of aliens who enter the United States unlawfully are of low education levels and poor, and that's one of the reasons why they've made the treacherous journey to the United States. And so you have low skill, low education level, impoverished people entering the United States. We have a very generous welfare state. Depending on the state the person enters, they may have access to a great variety of benefits, and as a result, you see this fiscal disparity. The other factor that's worth noting is that the U.S.-Mexico border has the greatest disparity in per capita GDP of any national border on the planet. The disparity in per capita GDP is the highest on the north side versus south side of the Mexico border. So then you take it down to the individual level. Why did Arizona act multiple times with their 2007 law to stop the unlawful employment of illegal aliens and their 2010 SB 1070 law? Is the fiscal cost. They calculated they were losing $2.6 billion a year. That's a gross figure, not net. $2.6 billion a year to illegal immigration in the state. Number one driver. If you look at the city of Hazleton, Pennsylvania, I've litigated that case and I'm still with them in the Third Circuit. I'll give you some figures there. The population was 2,000, a little bit over 2,000, 22,000 in the 22,000 in the 2000 census. Then the population went up to about 30,000 in 6 years. So the population increased almost 50% between 2000 and 2006. The reason? A meatpacking plant, one of the main reasons, a meatpacking plant was opened outside of the city limits, and large influx of labor came in. This is a town in the Pocono Mountains of eastern Pennsylvania. And the problem with this massive influx of new population is that Pennsylvania cities rely primarily on an earned income tax. They're not like cities here in Kansas, which rely chiefly on property taxes and potentially sales taxes. So the population expanded by roughly 50%, but the tax revenue for the city was a flat line. That was because many of the new people coming into the city were either too poor to pay any earned income taxes, or they were working off the books and not paying any taxes at all. So the city saw 50% of its expenses go up. As anyone involved in local government knows, when you've got a certain, you calculate the number of police officers you need based on the population of your city. Well, they need 50% more police officers, but there's no additional taxes. They need to provide for 50% more trash removal, which is provided as a local service there, but no additional taxes. You looked at the school district, some alarming figures there. In the 2002-2003 school year, the school district was spending $136,000 on English as a second language instruction. 4 years later, in the 2006-2007 school year, they were paying $1.1 million on ESL instruction, from $136,000 to $1.1 million in the space of 4 years. So, as a result, the city felt it had to act, and these fiscal drivers are present everywhere, because unlike the federal government, which can print more money or borrow from the Chinese when it's time to pay the bills, states and local governments are constitutionally required to balance their budgets. And so they have to address the fiscal drivers of this fiscal disparity. Okay, so let's now look at the legal issues. I'm about halfway through my time here. So these laws are in place, and predictably they were challenged. And I've been involved in many of these legal challenges. And I want to talk about some of the things that these laws do and some of the challenges that are brought against them. Now, I've mentioned what the local laws do. Typically, the local laws discourage the employment of illegal aliens either by creating an adjudicative process that says if there's a report that an employer is knowingly employing unauthorized aliens, then there is a process where the city can take away the license or the state can take away the license of the employer who's knowingly hiring, or they have a requirement that the city or state employers use E-Verify. I should rephrase that the private employers in the city or state use the E-Verify system. Arizona has done both, and those were both part of the 2007 law that I helped Arizona draft. It was introduced by Russell Pierce, who's been the legislative leader of these efforts there, and that was sustained by the United States Supreme Court on May 26, 2011 in Chamber of Commerce versus Whiting. So I think it's fair to say that all of the employment provisions have a bright green light from the United States Supreme Court, again, because of this decision in Chamber of Commerce versus Whiting. One other point about Chamber of Commerce. That case is the first time in 35 years that the Supreme Court of the United States weighed in on this issue. And so, being someone litigating these cases in courts around the United States, I'm used to citing Decanis versus Beca, the 1976 case I mentioned. Now we have Chamber of Commerce versus Whiting, and it's very important because it doesn't really change the landscape, but it updates the landscape with the United States Supreme Court weighing in on these preemption questions. Arizona's SB 1070, the most controversial provision in it, the one that got the most press attention, is the one that says anytime a police officer is investigating a crime or pulling someone over for speeding, in other words, is investigating some violation of law, and the police officer develops reasonable suspicion that the person he is addressing is unlawfully present in the United States, that police officer, if practical, must act on that reasonable suspicion and call the 24/7 hotline that Congress mandated back in 1994 for that purpose. Every day, approximately 1,400 police officers around the country, on average, call that hotline. And so it's something that's already been done for a decade and a half. But Arizona made it standardized procedure. So anytime an officer is in the middle of a law enforcement encounter, and it's practical, meaning he's got time, there's not an emergency he's got to rush off to, that the officer should go ahead and call the hotline. And that hotline is to ICE, Immigration and Customs Enforcement, and then do whatever ICE says. So if ICE says, yes, apprehend the person, we want to take custody of him, then do so. If ICE says this person is an unlawfully present alien and we don't have the resources to apprehend him, but that's your answer, then they can act on that. If ICE says, no, the person is lawfully present, the person is a green card holder, then they have gotten their answer that they need. Now, that's Arizona's SB 1070. The arguments raised against it by the Obama administration, that was another rather shocking aspect of the recent litigation here, is that the Obama administration weighed in. Never before, and I've asked other people to try to come up with an example, never before has the U.S. Department of Justice sued a state that is trying to assist the federal government in enforcing and reinforcing federal laws of any sort. There have been prior federal suits against states, to be sure, but usually when a state is directly trying to stop a federal law from achieving its objective. But the Obama administration sued Arizona and, of course, sued Alabama as well, and I was directly involved in drafting both of those laws. The federal government's argument is a preemption claim. And a preemption claim, for those of you not familiar with it, is that the states are not permitted to act here and that the federal government is the only entity that has authority under Article 6 of the U.S. Constitution, the Supremacy Clause. Now, there are two broad forms of preemption. There's express preemption, where Congress passes law, says no state shall do X. Well, there's no such law like that, and they don't make express preemption claims in these cases. So they bring an implied preemption claim. And an implied preemption claim is, well, Congress has passed Y, and this state law is in conflict with Y. It conflicts with congressional objectives. And that's the kind of claim that's been brought against Arizona's and Alabama's laws. And since I just have a couple minutes left, I'll just deal with those claims. The problem with bringing an implied preemption claim is that the plaintiffs, including the U.S. government, can't point to a specific act of Congress that even implicitly suggests that Congress wants the states out of this game, that Congress doesn't want this kind of state assistance. On the contrary, all of the federal statutes, and I've mentioned a few of them, suggest that Congress, especially in 1996, was desiring additional state help. So there's no federal statute that they can hang this implied preemption claim on. So what the U.S. Justice Department's argument, it's a very creative one, but I think it's one that must fail. And it is this. They say, well, we don't have a specific statute we can point to, but we will tell you that as a matter of executive policy, we don't want to enforce in this manner. We don't want to, Arizona and Alabama, for example, take seriously the federal law that says all aliens in the United States must carry their documentation on them. It's been federal law since just after the Second World War. They must carry their documentation on them, and if you're violating this federal law, citing chapter and verse, you're also committing a state misdemeanor. The federal government's answer is, well, we don't enforce that law anyway. We don't think that law is very important, so we therefore think our decision, our executive decision that this law is not important, has preemptive effect. It can't be important to you either, you states. So therefore, our decision to disregard it has preemptive effect. Two problems with that, and then I'll sit down. The first problem with that is preemption cannot be done by the executive branch. If you read Article 6 of the Constitution, only Congress or the Constitution itself can preempt. Preemption is a very significant act. It is displacing all of the states from the field. An executive whim, a memo from a lawyer at the Department of Homeland Security is not sufficient to preempt the states. Second problem with their preemption argument is that it's based on non-enforcement of the law. An executive desire not to enforce the law should preempt the states. The problem with that is Article 2 of the Constitution requires the President to faithfully execute the laws of the United States. So how can inconsistency with Article 2 have a preemptive effect under Article 6? So those are the two key problems with it. The Ninth Circuit ruled 2-1 against Arizona on this issue. In the case that they're certainly currently seeking review in the United States Supreme Court. In Alabama, on this specific issue, the Northern District of Alabama ruled in favor of the state of Alabama on this issue, and the issue is now pending before the 11th Circuit. So that's a quick summary of where we are, and I'll be happy to take questions in a little while later.
Well, good morning, everybody. I also would first like to thank the organizers of this conference for inviting me, and I think for providing a really challenging day and a half for all of us by raising one of the crucial issues of the day. Now, the issue, and I think Secretary Kobach made that clear from the start, is really one ultimately about the correct immigration policy for this country. Whatever we decide on the constitutional issue will not decide the larger question, which is really, I think, what is driving a lot of the current struggle between the federal government and the states. So we're having an underlying substantive issue which is fought out in terms of federal preemption power and generally the power of the states to assist or regulate, however you want to put it, immigration. Now, my focus is on the criminal area, because what we have been seeing in the last few years is the focus of immigration law increasingly in the criminal arena. And the criminal arena is one in which the states and the federal government have the power to legislate, and both have enforcement bodies. Now, since the late 1970s, we have seen a host of trends in criminal law that are now ever more infusing the debate in the immigration arena, sometimes explicitly, but oftentimes without anybody drawing these parallels. Now, one of the major issues that's been occurring, especially in the 1980s and the 1990s, is what is referred to as the federalization of crime. Evermore, the federal government had expanded its own enforcement power, in part through new laws, in part through increased enforcement in many areas, including drug and weapons offenses. And so many more people ended up in federal prison and in federal court than in state court, where they often could have also been prosecuted. In addition to that, we've generally seen ever more criminalization on both the state and the federal level, combined with incredible punitive harshness, which are encapsulated often in mandatory laws, which do not leave the courts any discretion. And that, I think, is another hallmark, the decreased discretion for judges, and often what we now seem to be seeing also, decreased discretion for prosecutors, at least in the immigration arena. If you want to encapsulate all of these developments, you only have to think about the war labels that we have put on a lot of these developments. We've had the war on drugs, We've not ended that. We also seem to have a war on violent criminals and, as part or as a separate element, the war on sex offenders. So all of these have contributed to ever more criminal developments. Now, what you're seeing, I think, is that these patterns are now being replicated in the immigration arena, where we have the federal and the state government increasingly jockeying over who can criminalize and ultimately penalize immigrants, or whether documented or undocumented for that matter, combined with a lack of discretion for the states in terms of what they want to do with respect to their immigrant population. And I will get to that in a few minutes, because for all the developments that Secretary Kobach outlined, there are also a host of counter-developments that are currently occurring, usually in different states than the ones he mentioned. Now let me unpack these claims. There are a whole host of issues that underlie the current legislation in the federal and the state arena with respect to immigrants. And again, Secretary Kobach mentioned a number of these. One is the cost of immigration, especially undocumented immigration to the states. Concern about immigrants taking away jobs. You see this in the discussion about Governor Perry's policies with respect to job creation in Texas. A concern, I think, that runs through many of these discussions, at least implicitly, about an impact on U.S. culture. And then finally, you see the public safety debate, which plays out with respect to crime generally, but also is often encouched in terms of terrorism. Now, when you look at legislation, you see many of these areas impacted. You have welfare legislation on the federal level in the 1990s, and the subsequent evolution of much of this into the states. You have the whole debate about education, in-state tuition for undocumented populations in the states, the DREAM Act on the federal level. You have a lot of discussion, at least, about legislation or policies with respect to these cultural elements, language being the most important, but also often religion plays a role, at least when you're talking about Muslim immigrants. And then last but surely not least, the issue I am focusing on, which is criminalization. Now, what I also want to point out to you is that much of this anti-immigration legislation is very localized. You see this. It is often communities that are making these decisions now. Sometimes it is states. And there are different immigration rationale and different demographic makeups for these communities. In a lot of those communities, you have not had large-scale immigration throughout the 80s and the 90s, but you suddenly see it in the last decade, and I think the numbers from Hazelton were somewhat interesting in that respect, that you suddenly had an influx of immigrants, largely from one part of the world, Mexico and Central America. Combine that with economic insecurity, which incidentally plays a lesser part in these decisions, but is surely also there, and you're ending up with very restrictive laws. So you have a localized perception of immigrant influx, sometimes based in reality, sometimes literally based on more perception, combined with a national rhetoric about immigration, and you're ending up with very localized decisions, sometimes state decisions, sometimes municipal decisions. So let's see how this is playing out in this interplay between the federal government and the states. The first thing I want to make very clear is, I think we have a very false view if we believe there is uniform federal law and enforcement, and then there are the states that are now creating these divergent paths. That's truly not the reality. We have a patchwork of federal enforcement, which is very different in different parts of the country, which is incidentally also true for our criminal laws. Let me give you an example, or some examples of that. For example, In the border states, you have fast-track enforcement in some of them with different ramifications for immigrants who are crossing the border without the permission to do so. You also have very different penalty levels that therefore are attached to that. For what's been happening is more criminal enforcement of that entry, but not in every part along the southern border and not along the northern border necessarily. And then different sentences and sanctions that result from that. In addition to that, you also have the federal judges reacting quite differently, for example, to immigrants in their courts. They often are granting downward departures, meaning they're decreasing from what would be the generally suggested sentence in reentry cases. Those are cases where somebody was deported and is now coming back, was deported based on a criminal conviction, is now coming back into the country. And their argument is that the person should get a discount on their sentence if they really were culturally assimilated and largely come back because they can't function in their country of citizenship and their family is in the United States. They're still getting substantial prison sentences, don't misunderstand me, but there's wide divergence in the federal judiciary as to what these discounts should be. The Federal Sentencing Commission has now said judges should consider that and should be allowed to give decreased sentences based on this. But what this clearly leads to is some judges will, some judges won't. So you have vast differences in different parts of the country, even in the enforcement of federal law. And I think that's important to keep in mind when you're now looking at state legislation. Now, I think one thing nobody disagrees with, that the states can't directly regulate immigration. The states can't pass naturalization laws. States can't do those types of things. The issue is how far can they go into the periphery of these laws to regulate immigrants once they are in the country, and that's really the debate. But what you're seeing is, first, a deputization of these states by the federal government. You see this in part of 287G, where the federal government said, we'll enter into agreements with you for you to basically enforce immigration laws. And you see it now with secure communities, where the federal government has said, by the way, this is not actually discretionary, this is a really mandatory provision, and you have to send us the data on the people you are holding. So you see the use of the federal of the states by the federal government. In addition to that, you now have the states trying to address the immigration issues themselves. And some of the states think there's probably different results that different states are trying to accomplish. I mean, in Arizona, there was talk about attrition by enforcement, which seems to create the impression that what Arizona really wants is move undocumented immigrants out of the state, either into other states, who can then decide what to do, or back into their home countries. Now, whether that's truly the intention or not, the effect is probably a more limited one. But the effect that probably all of these states are trying to have is creating action by the federal government. And my point is that they're actually getting a lot of action by the federal government in the criminal arena. But before we get to that, let me give you a sense of how this criminalization now is happening in the states under the new pieces of legislation that they have been passed. I think the first thing we have to keep in mind, our criminal laws, is that we seem to be living under the mantra of we don't ever forget and we surely don't ever forgive any transgression. And you see this in the immigration system where relatively minor offenses end up being penalized with deportation. So there's no graduated sanction. There's kind of an automatic, you do this, deportation has to flow from that, with relatively limited exceptions. Now, let me focus on some of these state laws, and I'll focus on Alabama's because there are quite a few of them. But just to give you a sense of how criminalization is occurring. The first one is the outright creation of new offenses. For example, making it a criminal misdemeanor to not carry an alien registration document, which you're supposed to carry under federal law, and you can't carry it because you don't have one because you're unlawfully present in the United States. It's a misdemeanor to apply for, solicit, or perform work. It's a felony for an undocumented person to enter into a business transaction with a state, which includes applying for or renewing a driver's license or a business license. Now, also, what we're seeing is the extension of the applicability of criminal law because of some changes in another area of the law. Best example are driver's licenses. You're supposed to have your driver's license, right, when you're driving. We all are. You don't carry it, it's an offense. So, if you're now telling me that I can't get a driver's license because of my status, but I have to drive, of course I'm violating the law. Almost by definition, I guess I have a choice not to drive, if that's a real practical choice. But by denying undocumented populations access to a driver's license, you automatically then make them run afoul of that particular portion of the law. So this is I think the interplay also between civil law and criminal law that you're seeing. Now, there's a second component to this, and that's the criminalization of non-immigrants, or of U.S. citizens and documented immigrants, I should say more accurately. So if you're assisting the undocumented with work, housing, transportation, even though knowingly is generally put into these laws, you're running afoul of the law. If you're looking at Alabama's law, it's unlawful to conceal or shield an alien who is unlawfully present in the United States or to transport an unlawful alien. I want to give you a very disturbing parallel to this. In France and in Italy, fishermen were criminally prosecuted when they saved shipwrecked migrants from the ships that are coming from Africa and the Middle East and brought them to Italy and to France because they were transporting people who didn't have the right to enter Italy and France. I don't think any one of us want to get to that point in our law, but you'll see the danger in going down this line. I think the implicit message in all of this is stay away from people who you may believe are undocumented immigrants, maybe even people who are immigrants. And then it's left to the citizen to figure out who these people could be, since obviously you don't have it stamped on your forehead whether you're documented or not. And that's when I think you're running into these discussions about racial profiling, language profiling, all of these types of issues. But I think my concern is a slightly different one, that you're really running into a culture of surveillance and snitching when we're going down this road. And at least I don't believe that this is what this country should stand for. Now, one other point, you may think you're not too disturbed by any of these things because many of these offenses are not felonies but are misdemeanors, and generally the direct consequences are relatively manageable, fines of very limited jail time. But I think we should consider the fact that there are a host of collateral sanctions that often result from misdemeanors, and perhaps more importantly, that our modern information society makes it possible to discover these for the rest of your life with possible housing consequences, with possible job consequences. So a criminal record, even if it's for a misdemeanor, I don't think it's anything that we should not take seriously. Now, I think the other issue is one that Rick Sue, who is on a panel this afternoon, wrote about, which is the question that a lot of these state laws are now mandating every part of their state, obviously, to enforce the law in a particular way, which some of the localities may not be interested in doing. And in fact, you have that split in Arizona, where some of the municipalities were actively opposed to the legislation because they wanted to treat their immigrant population population differently. So even within the states, you often have quite different perceptions. And then the last one is just a question not of substantive criminal law, but one of criminal procedure, where state officials now obviously have heightened ability to arrest and to detain as part of these new state laws. If you're looking at Alabama's, for example, now you have the ability as an officer to ascertain immigration status upon a lawful stop. And then if there is obviously no documentation to be gained, you're running into all the legislation that we've talked about, and then you have the ability, and in fact you're mandated to bring the person in to hold them until the Immigration Service takes over and it turns out that they are in fact checking out to have documents. And I think it's important here to think about the relevance of traffic stops. I suspect we've all either been stopped or have not been stopped but checked through an informal traffic stop. And if you're looking at the importance of traffic stop in the immigration area, I just want to leave you with some numbers. Federal apprehensions by immigration authorities decreased dramatically between 2001 and 2009, namely from 1.6 million to 600,000. Immigration detention, however, increased by 85%. So that has to mean that somebody other than the federal government is clearly initially arresting and holding people. And it is state officials, and it is largely through traffic stops where it's relatively easy to figure out whether somebody is documented or not, although they may also be a very crude way of measuring someone's criminality. Now, let me play these numbers out for you just a little bit more, because what you're running into is a market effect of this criminalization. You have an increase in the number of non-citizens in the criminal justice system and in prisons. So in the federal system, it's actually a relatively small increase in the last few years, but it leaves you with about 27% of the federal prison population being non-citizens. Well, that may not be that surprising because immigration law, strict immigration law, is federal law. So you have 68% of those 27% are in fact convicted of immigration offenses. The second largest category, 20%, is drug offenses, which is also not surprising because it's generally a large percentage of the federal prison population. Now, in the states, the numbers are somewhat trickier, but we have the numbers at least the federal government numbers of non-citizens who are without status in state and local prisons. And from 2003 to 2009, you had a 35% increase. Now, most of those, again, are immigration drug offenses. But interestingly enough, a large proportion, 39% of the arrests of these people were done for traffic violations. So traffic becomes an ever larger part of a way in which we are figuring out who the undocumented are. But I want to caution you, that's not true for every state. Arizona had the highest percentage of undocumented convicted of traffic offenses, followed by Texas at 11%. But then you're looking at California and Florida, which had 4% and 3% respectively, and New York, which had less than 2%. So state enforcement dramatically different, in part because of the laws that they've passed, in part because of what it is they are enforcing. Now, what you're seeing, I think, also is somewhat of a circular argument. We're having more undocumented in prison. They constitute a higher public safety threat. We have to legislate more against them. More end up in prison, and it becomes this spiral that proves what we're trying to prove, right? That the undocumented and non-citizens in general are dangerous, morally inferior, can't comply with our laws. Therefore, we have to incarcerate and deport them. So that's, I think, those are all the types of issues you want to think about. Now, my time is almost up, so I want to leave you with, I think, a few of the major questions that arise from that. You see an interplay between state and federal. It is not as separate as I think the current constitutional debate makes us believe, at least not in this area of criminalization and crime and immigration. But what's the stop? Because of the way in which we're debating this as a state-federal issue, as a question of preemption, there's no larger discussion about the big issue or about any type of human rights considerations. The Supreme Court, in its decisions in Padilla, now talks about a protection under the Sixth Amendment right to counsel, which is an interesting idea, but really it deals with a very limited question of rights for immigrants to be told about the consequences of a criminal conviction. And I just want to contrast this with another court, the European Court of Human Rights, which has been trying to play a relevant role from a human rights perspective in Europe, which has been equally restrictive on immigration. And here you see a court that's been very actively trying to protect, for example, the undocumented, who have only minor criminal records, if any, but have children who are citizens, to keep them in the country. They've also been dealing with people who have lived many years in a country where deportation does not become an option, even if the crimes become more serious, because they don't feel that you can deport someone who's basically criminogenic tendencies may have actually been trained in the country in which they are living. So you have a very different institution that puts a certain different stop and look at these issues. I don't believe we currently have that, and I also believe very strongly that however we come out on this debate about whether Alabama and Arizona have the right to pass these pieces of legislation, we will not see an end to this discussion about immigration until we've tackled the underlying substantive question, which is what should our immigration law look like? And don't look for help from the criminal arena. While the states have been doing a great job, forced by budget cuts, to deal with the question of should we really be incarcerating everybody, which I would ask this question generally, that's not a question we're asking with respect to immigrants, in part because the federal government can print as much money as it ultimately likes to. Thank you very much.
Well, if everyone here is tired, I've been traveling 23 hours, so I got you guys beat. So I hope you guys can suck it up a little bit for me for about 20 minutes. Let me get my PowerPoint. I have a fancy PowerPoint for you guys, so you can have visual aids, so you guys can stay awake a little bit. I hope it helps. Before I start my presentation, again, I would like to extend my gratitude to the Washburn School of Law Center for Law and Government, especially Reggie Robinson, for inviting me to speak. And thank you. And I'd also like to thank the Washburn Law Journal for their courteous reception and welcoming me and publishing my forthcoming article, which I'll discuss more tomorrow. Also, before I start, I want to issue a disclaimer that this presentation on constitutional and immigration law contains only the opinions of myself as a legal academic, not the United States Air Force, not the Department of Defense, or the federal government, nor do I speak on behalf of any nonprofit, political advocacy group, or political party. And if anyone has any questions about that, you can see me after, because I know sometimes things get confused. As for my presentation today, I want to discuss the constitutional landscape of state governments and immigration law. As we all know, it's been 15 years since Congress enacted any comprehensive immigration reform. As a result, we are left with a severely flawed immigration system. Whether you are for strict enforcement of the current system, greater immigration controls, or for a more lenient and open immigration system, I believe we all can agree that the system has problems and is in desperate need of reform. The main problem, however, is the inaction of Congress on comprehensive immigration reform. Certainly, the subject remains an issue of heated debate at every congressional election, but little, if anything, has been done. This is not to say that Congress cannot be propelled by the states for it was the myriad of state laws that led to the 1986 Immigration Reform and Control Act. And a similar scenario may present itself today. But before I get to that discussion, I wanted to discuss the origins of federal plenary power over immigration and why the states are vested with little, if any, autonomy on the subject. I think I pressed the right one. Here we go. Before the United States declared independence in 1776, the law of nations prescribed that every nation or sovereign was the gatekeeper of its borders. Hugo Grotius described immigration law as a, quote, friendship between nations. In other words, immigration was not a right, but a submission to the receiving government as the tacit condition of protection. This basic legal construct continued unquestioned throughout the 18th century. Influential commentators such as Samuel Pufendorf, Vattel, Blackstone, William Defoe, and Matthew Bacon all attested to this rule of law. In fact, probably few of you know that immigration and naturalization policy became an issue of discontent between the colonists and England, as is evidenced by the Declaration of Independence. Often mistaken by free migration advocates as supporting a right to immigrate, the grievance had to do with Parliament and the Crown usurping what was seen as colonial authority. This is because, over time, the idea of virtual representation made less sense as effectuating constitutional happiness, and the colonists wanted to establish a government built upon the consent of the governed, with equitable principles diffused throughout. This included the power to define who was a member of the political community. The Declaration's references to the laws of nature or nature's God had nothing to do with individual natural rights. Instead, it had to do with the law of nations. For this was what 18th century commentators often referred to as the law of nature or nature's law. Thus, from our very inception, we as a nation acknowledge the constitutional significance of the law of nations over foreign affairs, peace, commerce, and even immigration. Although the Declaration granted Continental Congress no powers or duties, the nation's greatest legal minds understood these powers must be vested with the national body. Otherwise, the Continental Congress would have been able to arrange an alliance with France or negotiate a treaty, the Treaty of Paris. And another fun fact, perhaps few of you know, is that the 1776 Continental Congress offered our first immigration amnesty. As a means to lure German auxiliaries from the British lines, the following proclamation was issued. Whereas it has been the wise policy of these states to extend the protection of their laws to all those who should settle among them, of whatever nation or religion they might be, and to admit them to the participation of the benefits of this practice, as well as its salutary effects, have rendered it worth it being continued in future times. Now, much can be learned from this proclamation in terms of early American immigration law. We see references of protection and participation for foreigners as a matter of good foreign and domestic policy. However, we also see that this reciprocity rested on the tacit condition that they are admitted. Unfortunately, federal plenary power of immigration, foreign affairs, naturalization, and citizenship would be short-lived upon ratification of the Articles of Confederation. During this brief period in our constitutional history, all national policies required the consent of 9 states, which proved to be rather difficult. What resulted was 13 states enacting 13 different policies concerning these issues. The situation reached a height that George Washington, James Madison, and others became concerned of an international incident, or at least a series of events that would break up the Union among foreign affairs. Thus, when the Constitution was drafted, the founders followed the standard international construct and intended for plenary power over immigration, naturalization, citizenship, and foreign affairs to be vested with the federal government. Indeed, the 1787 Constitution says nothing about immigration or citizenship, but the powers were naturally understood to be implied with national sovereignty. This was affirmed by the writings of prominent founders such as George Washington, James Madison, Alexander Hamilton. The power of immigration was seen as central to national self-preservation from foreign threats as well as to preserve Americans' political system. In fact, numerous Supreme Court justices attested to this fact in the early republic. For instance, in 1793, John Marshall argued before the Chief Justice John Jay and Associate Justice James Iredell, Congress has the right to legislate over foreigners. This goes to rights of all kinds. In the very same year, Chief Justice John Jay identified the law of nations as part of federal authority, writing, "The respect which every nation owes to itself imposes a duty on its government to cause all its laws to be respected and obeyed, and that not only by its proper citizens, but also by those strangers who may visit and occasionally reside within its territories. There is no principle better established than that all strangers admitted into the country are, during their residence, subject to the laws of it, and if they violate the laws, they are to be punished according to the laws to maintain order and safety." In 1798, defending the Alien Act, Associate Justice James Iredell issued a charge to the grand jury and defended federal plenary power over aliens. He stated, "There are certain conditions without which no alien can ever be admitted, if he stay ever so long, and one is, he has behaved as a man of good moral character, attached to the principles of the Constitution of the United States, and well disposed to the good order and happiness of the same. If his conduct be different, he is no object of the naturalization law at all, and consequently no implied compact is made with him. Besides, any alien coming into this country must or ought to know that this being an independent nation, it has all the rights concerning the removal of aliens, which belong by all the law of nations to any other. That while he remains in the country in a character of an alien, he can claim no other privilege than such as an alien is entitled to, and consequently, whatever risk he may incur in that capacity is incurred voluntarily, with the hope that in due time, by his unexceptional conduct, he may become a citizen of the United States." What these examples are to impose upon your mind is that plenary power of immigration was not formulated out of thin air. For the past 100 years, advocates and intellectuals seeking a constitutional right to immigrate have asserted the United States cannot possess an unbridled power of immigration. In fact, just this Supreme Court term, 33 immigration law professors submitted an amicus brief, I don't want to butcher the case name, I think Judulong v. Holder, asserting this very fiction of law. However, as I hope my scholarship and these few historical examples have shown, this understanding of federal immigration plenary power cannot be squared with our history. Federal immigration power is virtually unlimited. The question that remains is, where do the states fit in? The question is interesting because until the late 19th century, federal regulations of immigration were virtually non-existent. Other than the short-lived 1798 Alien Act, issues involving immigration became a matter of state law. Now, the states were never vested with immigration authority outside any traditional powers. It was the situation of the times that required the states to legislate in the field as a means to preserve their political entities. Now, does this same situation present itself today? Is immigration reform so out of date and flawed that the states must step into the federal sphere? In terms of politics, the answers differ depending on who you ask, Democrat or Republican, liberal or conservative, and even the members of our panel today. As a matter of actual litigation in the courts, the same holds true with differing theories of preemption analysis. However, absent federal acquiescence, any return to states' autonomy or diversity over the field of immigration is arguably inconsistent with our Constitution's original framework and spheres of government. I know many people in this room don't want to hear that answer and disagree as a matter of policy. But this issue was settled in 1787, and today we maintain a long strand of constitutional jurisprudence unequivocally reflecting that the power over immigration rests with the federal government. What the Supreme Court has properly articulated is that the states are left with the power to work within this basic constitutional construct and may vest their respective privileges or immunities to aliens residing in their territory. Now, before I get to that point on privileges and immunities, I wanted to discuss how the states may work within the federal immigration scheme to assist the enforcement of immigration law. Such cooperative effort does not mean that the states can parrot or copy the federal law or simply make a federal violation a state violation. As was seen in Chamber of Commerce v. Whiting, the states must work within the framework prescribed through savings clauses or traditional state services like businesses licenses, state contracts, and the like. Today, bills like SB 1070 and subsequent versions are arguably overstepping the bounds of state power. I say this for two reasons. First, if the Constitution was drafted to prevent embarrassments in terms of immigration and foreign affairs, it is inconsistent with the Constitution for the states to pass legislation that step too far in the field of foreign affairs. This legal doctrine is somewhat reflected in the Ninth Circuit Court of Appeals opinion in the United States v. Arizona. I won't repeat that for you, but what I wanted to say is while I do not agree with the court majority that they relied on a brief from foreign state presidents, the United Nations, and other international bodies in coming to this conclusion, nor do I agree that they should have applied to Section 2B, the enforcement of Section 6 could have grave foreign policy considerations. And here's Section 6. A warrant unless for immigration violations is not only inconsistent with 8 U.S.C. 1252C, but would be to place immigration enforcement in the hands of state officials without federal permission. Now, if a state officer had been instructed by federal immigration authorities to detain an individual or took steps to cooperate with federal authorities, this would be constitutionally permissible. However, Section 6 is phrased in a fashion that usurps our delicate constitutional balance in the area of foreign affairs and immigration law. The second way bills like SB 1070 overstep the bounds of state authority is confliction with the federal scheme. In other words, the question boils down to, does the state law contradict, impede, or cause difficulties with Congress's purpose and objective? Answering this question is always difficult for the courts, and particularly difficult in terms of Sections 2B, 3, and 5 of SB 1070. One could reasonably argue that these provisions insist in enforcing the federal scheme and are in line with Congress's manifest purpose of deterring unlawful immigration. Certainly, there's little, if any, disagreement that it is unlawful to migrate without the consent of the government. Those that violate this law do so in contradiction of our Constitution and are seeking that the states, and seeing that the states are part of that union, it is arguably within the state's power to assist the federal government. At the same time, it may also be argued that state enforcement could have dire international consequences because it conflicts with the federal scheme. The Immigration Code is rather detailed, and it's equally reasonable to argue that the federal government, if the federal government wants the state's assistance, they will expressly provide the means and bounds by which to do so. Needless to say, in the constructs of our current federal immigration scheme, there are compelling legal arguments for both sides. Naturally, bills like 1070 are not the only way the states are seeking to deter lawful immigration. Some states have enhanced voting protections to ensure political integrity at elections. Here also, the Constitution provides a delicate balance in different spheres of government. Take, for instance, a recent Arizona law requiring documentary proof of citizenship in order to vote at federal and state elections. In Gonzales v. Arizona, the Ninth Circuit found the citizenship requirement to be preempted by the text of the National Voting Rights Act and an interpretation that is confirmed for anyone who wants to look at the legislative history. At the same time, however, the court confirmed that the states may impose their own election requirements separate and distinct from the federal government. Thus, proof of citizenship at a state or local election is a tool by which the states can deter unlawful immigration within their sphere of government. The same holds true for state representation, but this policy to deter unlawful immigration comes at the expense of ostracizing the state's entire immigrant population and even non-voting age minors. As it stands today, federal apportionment includes total population, including lawful and unlawful immigrants, as a means to determine congressional apportionment. This is not to say that unlawful immigrants are constitutionally protected in federal apportionment. The issue has never come before the Supreme Court or been litigated on the merits by any court for that matter. If one follows the original intent, meaning, and purpose of the 14th Amendment's apportionment clause, unlawful immigrants may be constitutionally excluded from federal apportionment based on lacking the necessary allegiance or lawful domicile. As Judge Timothy Farr aptly put it in his 1867 treatise, as you can see, he writes at the end, the whole number of persons in each state cannot mean everybody on the soil at a particular time, nor exclude everybody who may not happen to be on it at the same time. And of course should be authoritatively construed by the lawmaking power. What he was referring to is Section 5 of the 14th Amendment, which gives Congress the power to legislate on the amendment. And also he questions whether it includes citizen inhabitants, residents, temporary or permanent, strangers, aliens, Indians. One could argue that unlawful aliens would not qualify. Now, my history shows that, from what I've done, that people that were domiciled would have to be counted. That was the purpose. But the question is, what is domicile? But I want to stress that excluding unlawful aliens from apportionment cannot be litigated in the court of law. It is a non-justiciable political issue. And until Congress passes any legislation on this topic, unlawful immigrants remain part of our national body politic, While many might find the status quo to be politically unjust, it is the federal system we are embodied with. However, as with state election rules, what applies to the federal government does not apply to state governments. The Supreme Court has ruled on a number of occasions that states and municipal governments may redistrict according to citizens of voting age population, what's known as CVAP, voting age population, known as VAP, or registered voting age population, known as RVAP. As I mentioned before, exercising this option comes at a great cost. Legislators must ask the question, are the benefits of deterring unlawful immigration to come at the cost of ostracizing minors and lawful immigrants? Certainly, the legislative choice is constitutional, and it sends a message to Congress that we are in dire need of immigration reform. But is this a good policy decision? These are just some of the difficult questions I think face state legislators, and as people from all political backgrounds clamor for immigration reform. Now, I could talk about the power of states over immigration enforcement, but I also want to discuss how states and municipalities are arguably undermining the federal immigration scheme, too. As most of you know, the states have the authority to offer immigrants their respective privileges and immunities on par with its citizens. This means that states and municipalities can offer immigrants the right to vote, access to government, and other privileges. It is an attribute to state sovereignty that may be used to lure immigrants into the political community. But in terms of the law, what happens when states and municipalities offer these privileges and immunities to persons not lawfully present? Or do so in a manner that arguably undermines our federal scheme? Is it constitutional to reward persons that have not subjected themselves to the Union or comply with immigration procedures? Take, for instance, a recent ordinance by Dayton, Ohio, to attract immigrants living in strict enforcement states like Alabama and Arizona. The ordinance works within the traditional spheres of government to offer some great incentives to assimilate the immigration population, such as language training, business assistance, health care, education, and even a non-voting position within its political community. These are all constitutional exercises of a state or local privileges and immunities. At the same time, however, the ordinance offers municipal identification cards to immigrants, quote, not eligible for any other accepted identifying document, unquote, and promises not to investigate immigration status unless for serious or violent crime. These latter measures are arguably undermine our federal scheme, for they acquiesce to unlawful presence. Another recent example of how states are undermining the federal scheme is such bills like the California DREAM Act, which allows qualifying unlawfully present aliens to receive in-state tuition, loans, and government grants. Proponents of the act in similar bills claim to be a progressive triumph in civil rights and equality. They also assert that these laws are constitutional, however. If we use history as a guidepost, I believe the bill does exactly what the Constitution was ratified to prevent: the influence of foreign policy at the state level. Just as it is unconstitutional in the states to enforce federal immigration law on their own or create new immigration controls that may negatively impact foreign policy, so too must it be unconstitutional for states and municipalities to undermine our federal scheme by affording those unlawfully present immigrants state services and benefits. Ask yourself the following legal question: is it embarrassing to the federal government and our national rule of law for a state to reward and protect those whom have not subjected themselves to our national consent? If you answer yes, we are in agreement with the law. However, if you answer no, then you must also be willing to accept that states have the authority to enforce immigration controls unless expressly preempted by the federal government. For if we're going to claim that the states have the authority to reward foreigners in contradiction of our national constitution, they must also have the constitutional authority to maintain the police authority to pass bills like SB 1070. In closing, I'd like to say I know that people across the political spectrum, and even in this room, disagree with much of what I've said. The subject of immigration law causes a mixture of emotions and political convictions to the nexus that we only listen and hold on to what we want to hear, or maybe what we socialize to perceive. However, our individual virtues and moral compass need to be cast aside when conducting constitutional interpretation and analyses. It is the very essence of being a legal professional. I want to emphasize that good public policy and constitutional interpretation are not one and the same. The former is guided by we the people through our legislatures, and the latter provides the legal guidepost by which to work from to create that policy. To phrase it another way, just because the law may be constitutional, it does not make that law good or prudent public policy. If you have any further questions about what I discussed here, here's 2 of my articles discussing the state's role in federal immigration power. And thank you for your time.